your guys are already on this call. And if I haven't had a chance to meet the few of you that's on this call, quick introduction about who I am. My name is Jerry Wu. I'm with Stewart Title. I have worked in the title industry and have been a title rep for a little over a decade now. And I've worked very closely with the Tri-County Association of Realtors over that last 10-year plus period. So thank you so much, Laura. Laura has, spearheaded Tri-County Association of Realtors for, I don't know how many years, but 10 years. So she's done a marvelous job. And so thank you, Laura, for having me. And again, guys, this is the title class that we do once a quarter. So this is the fourth one so far for the year for Tri-County Association of Realtors. And Laura and I were just talking, and we're going to be doing another 4 next year, again, which will be once a quarter. So I'm thinking about doing some more of these in person. We'd love to get your thoughts on the call. If you guys, once we're done, if you're like, I'd really love to Zoom, or, hey, I'd love to do more in-person events next year, even with everything COVID kind of calming down now, or, I still prefer Zoom, whatever it may be, these classes ultimately are for you guys. So we'd love to hear your thoughts and your feedback on these as well. All right. So the class is recorded. So if you wanted to access a lot of this information, some of you heard what Laura was saying, a lot of these classes will be available on the video after about 2 days on the Tri-County website, which is just tricorealtors.com. So you can access that on the website along with any of the other classes, I'm presuming, not just the one that I'm giving you guys here now. All right. So with that said, I have left my contact information in the chat box. All right. Feel free to contact me at any point in time. Since it's just maybe a few of us on here, if you do have any questions, you're welcome to just unmute yourself. I encourage you to just unmute yourself rather than use the chat box, because I may miss the chat box, but I don't want to miss your question. So just unmute yourself, ask your question, and then I'll do my best to answer it at that point. All right. So in the next 45, 50 minutes or so, I'm going to give you guys an overview on title insurance. All right. So we'll talk, I don't know everybody's. Yeah.
Bye.
Oh, all right. I'll see you. Have a good one. Have a good day. Enjoy.
Thanks, you too.
All right. We'll go over title insurance, and basically we'll talk about the basics of title insurance, who pays what, all that other things. And then the next thing I want to talk about for you guys is on vesting, right? And I think vesting is where a lot of agents have questions. So joint tenants, tenants in common, trust, if my seller had title under trust, the trustee died, what do I need, right? If they're incapacitated, if they're in a senior living facility, what do we do? Like, what documents do I need? So we'll talk about all those things as well. All right. And then if we have some more time, we can take some more questions and even talk about some red flags on title and so forth. Sound good? All right. Now, I'm going to start sharing my screen and we will get this party going. So first and foremost, hopefully you guys can all see this flyer on the screen. If you don't, please let me know. But let's first and foremost talk about what is title insurance. I don't think we need this. So title insurance protects you against covered title defects like a previous owner's debt, liens, and other claims of ownership that may have been instituted prior to purchasing your home. Now, what does that really mean? Okay, I think I don't really even understand that if I were to read it. All that means, guys, is that you have insurance, ownership insurance on your home. That's really all it means, okay? You have ownership insurance on your home. And if anything from the past or anything, any liens or any issues relating to the prior owner or prior owners were to come back and threaten the ownership of your property, then you would be covered. Really, that's all it is. It's ownership insurance, all right? So how is this different than most traditional insurance policies? Well, I think most of us are familiar with insurance, right? We all have auto insurance. We most likely all have health insurance, and most insurance all work in the same way, meaning we pay a premium maybe once every 6 months, maybe once every 12 months, in case something were to happen, right? So of car insurance, we pay maybe every 6 months in case we get into an accident, and then the insurance company will do a lot of research. Well, title insurance works backwards, all right? Meaning all the research is done upfront. Upfront meaning during the time of escrow. So all the research is done upfront during the time of escrow. And then there's just a one-time payment at the time of closing. And that one-time payment will will cover our insured, our buyer, for as long as he or she owns the home. So that's the main difference between these two. Now, generally speaking, in most transactions, there are two types of title policies issued in most transactions, all right? Especially if there's a loan. You have your owner's policy, and then there's a loan policy. Let's first talk about the owner's policy right here. So the owner policy is the one that I've been mostly talking about, where it ensures the ownership of the home, all right? So let's give you, I'll give you a couple of more examples. So let's say you buy a home, and then you all of a sudden found out that there were some delinquent property taxes associated with the seller, right? Maybe the seller didn't pay certain property taxes and it wasn't caught during escrow, and now it's still showing, delinquent, but now you own the home, so, you're responsible for it now. Well, but because you have title insurance, you can file a claim with your title insurance company, and the title company will take care of that because, again, it's not related to the buyer, it's something related to the seller. Or I'll give you another example. What if there was an HOA lien, right? Because the HOA may be a little bit late in recording a lien. Maybe they didn't record it against the seller when the seller still owed the property, and now all of a sudden the seller already sold it, they recorded it, and now it's on the title of your home, right? But it's related to the seller. So that is then still covered under your title insurance policy. Another example, something a little bit smaller. Let's just say, for example, you bought lot 5 of tract 1, 2, 3, 4. Okay, that's the property that you bought. Okay, lot 5 of tract 1, 2, 3, 4. But then escrow made a mistake. They wrote on the grant deed lot 4 of tract 1, 2, 3, 4. Right? It's a typo. It happens, human error. But now technically, you don't own the property that you just bought. Well, that is covered under title insurance. Or something a little bit bigger. What if the person that sold you your property wasn't really the owner? There was some fraud going on, right? It was some seller pretending to be the owner so they can collect the money and commit that fraud and run away. So, well, since technically this real seller didn't sell you the property, your ownership is now threatened. So those are all examples from small to big on how ownership can be threatened. And those are all examples where your title insurance coverage, specifically your owner's policy, would come into play. All right. Now, this particular owner's policy is not legally required. Right. In fact, title insurance and escrow is not legally required for any sale. A sale can happen legally without title and escrow. And sometimes you might even see title insurance as optional on certain loan documents. And that's completely true. There's no law that says title insurance or even escrow is legally required. But here in the state of California, it's very difficult to do a file without title insurance. For example, if there's no title insurance, the buyer's lender won't loan on the property. Right. So the buyer's lender will just say, hey, if you're not getting buyer, if you're not getting a title insurance policy, I'm not giving you a loan. Like, it's not doing it. So, or if there's no title company, escrow is not going to do this transaction. Escrow is saying, like, we can't really do our escrow unless there's a title company because they do part of the other part that we do. Right. So legally, title and escrow not required, but it just makes it much more harder to do. Now, this particular owner's policy, I think you already know, it insures the buyer of our property, right? Insures the buyer of our property. But this owner's policy is typically here in the state of California paid for by the seller. All right, so the seller pays for it for the buyer, and then the buyer will pay for it for the next owner. Now, this is not legally required to be done this way. If it can be negotiated, so say for example, somebody will say, you know what, I'll give you a super great price, but buyer pay for all fees, something like that. So nothing is set in stone. Perfect example is for new homes. If you go buy a brand new home, when homes were flying off the shelves, the builder will just say, hey, buyer, you pay for everything, right? All fees are yours. So again, nothing set in stone, but the typical standard way of doing business in the state, Southern California at least, is the seller pays for the owner's policy for the buyer. And this policy is good for as long as the buyer owns the home. For as long as the buyer owns the home. Sorry, my 2-year-old is trying to come in and look for me. So this means if the buyer owns the home for 50 years, they have a title insurance policy that covers them for 50 years. But the key word here is for as long as he or she owns the home. And that's the key word. Meaning, if say Joe Buyer, right? Joe Buyer buys the home, and then a year, 2 years, 3 years later, however long later, he decides to deed and transfer the property over to his sister, Mary, right? Well, now Mary has the property, which is fine, but Mary then does not have title insurance. So if there were a title issue that were to occur, then Mary would not be covered because the title coverage was technically for her brother, the originally insured. So in situations like those, again, Mary could have the option to go to a title company to have that transferred insured. But again, title insurance is not legally required and she doesn't have to if she doesn't want to. But sometimes it's a good idea to do so. And sometimes it's not that practical. If you guys run into a situation where there is an option like that, call me and I'll kind of explain to you the differences, the pros and cons of getting an insurance policy again, or just kind of leaving it as is. All right. Okay, now the second type of policy that gets issued is a loan policy. Now this specifically applies to if the buyer is taking out a loan to buy a property, right? So let's say the buyer, in order to buy this property, he or she then has to go to Wells Fargo to take out a loan. Well, Wells Fargo is going to say, well, buyer, we're happy to give you this loan, but you need to buy us a title insurance policy. And that's then called a loan policy. Now, why would the lender need a title policy? Well, lenders, they want some insurance as well. They want to, what if the borrower, the buyer isn't who he or she says they are, right? What if, again, it's fraud? They want to make sure that their loan is insured and protected. Also, lenders, they're very, very particular about the position of their loan, right? So if they're lending on first position, they want to make sure that there's no other lenders that's senior to the particular loan. So they want to get an insurance policy to kind of protect and make sure that, there's no other lenders out there that they're not aware of that the borrower has. All right. So I'll give you the perfect example. So let's say your friend comes to you and they say, hey, Chris, can you lend me, $1,000? And you're like, yeah, sure. I have $1,000, I can lend it to you. But if you then later, and then you say, hey, do you owe money to anybody else? The guy says, no, just, that's it. I owe somebody $500. I really just need to pay them off. If you can lend me $1,000, I'll pay them off. And then, I'll pay you back next month or something like that, right? But what if you found out that that wasn't the case, right? What if you lend him $1,000 and then you find out later that he actually owns other people $2,000, right? Or $3,000 or $10,000, and he owes money to much more people? Well, there's a very good chance you're not getting that $1,000 back anytime soon, right? So that's the type of situation that the lender is trying to avoid. And that's why they want some type of insurance policy to insure them if that were to happen. Hopefully that makes sense. Now, this loan policy is typically paid for by the buyer. All right, the buyer pays it for the lender, and it's only good for the term of that loan. This means if a loan gets refinanced, right, then they have to buy a new title policy, specifically a new loan policy. So if you ever see if you ever refinance your home, you're going to see escrow fees and title fees. Well, that title fee is really for a new loan policy. All right. And it doesn't matter even if it's the same lender. It could be, you could have your loan with Wells Fargo and then you refinance with Wells Fargo. Well, it's a new loan, so a new loan policy will be needed. And generally speaking, it's required even for like line of credits, reverse mortgages, regular traditional loans, jumbo loans. Lenders will always usually require a loan policy. All right. So how long does the policy last? We talked about that already. And then costs. So typically the cost of these owner's policy and lender policy is dependent on the price of the home and then the amount of the loan. So the more expensive the home is, the more expensive the owner's policy is. The higher your loan amount, the more expensive the loan policy is. So it just kind of depends on that. Now, something about fees of title insurance. Title insurance is insurance, meaning it's governed by the Department of Insurance. We have to follow certain compliance. And so it's a very regulated thing, okay? What I'm trying to get at is the fees for title insurance across most title companies are almost usually the same, pretty close, okay? Maybe off by $100. So for a $500,000 home, maybe we're at $1,500 and another title company is at $1,600. Okay, so it's normally not a huge difference. You'll never find a title company that'll say like, I'm going to issue you a $500,000 policy for $1,500, and then you shop around, another company is going to say, I'm going to issue it to you for $3,000. Like, it's pretty rare to see that happen. Usually title companies are usually only off rates are about $100, give or take. And when we're talking about $2,000 title fees, $2,500, sometimes $100 is not that big of a deal, generally speaking. But I guess the point I'm trying to get at is, at the end of the day, this is an insurance policy. And I know most of the time, sometimes you get to choose who you get to work with in terms of title companies. And at that time, I hope you consider us, but sometimes you don't. But at the most, try to stick with larger title companies. All right. So by larger title companies, I mean title companies that preferably are not brokerages. So for example, so Stewart, which is where I'm at, where we underwrite our own policies. I used to be at First American Title for many years, and they underwrote their own policies. The reason is if it's a smaller title company, they go out of business, then that policy ends up floating back to whichever underwriter that wrote that policy, and sometimes it's hard to track. We saw this a lot back in 2008 when the market crashed, and a lot of these small title companies went out of business, and the title policies for these homeowners just kind of floated back to the underwriting company, which sometimes it's very hard to determine who those people are. So just kind of a word of advice on that. All right, so that's a quick overview on title. Does anybody have any questions before we move on to vesting? Feel free to, if you do, just unmute and ask. And for those people that just came in, I'm gonna leave my contact in the chat box again, in case you need to get a hold of me after. Okay, if there's no other questions, let's move on to the vesting portion. And the vesting portion, we're going to talk about, again, single man, married man, joint tenants, tenants in common, all those things we're going to talk about. All right, now, first and foremost, what is vesting? Vesting is another way of saying estate planning. All right, it's another form of estate planning. And estate planning, all that is what happens to my stuff after I die? Right? What happens to my house? What happens to my assets, my car? That's estate planning. And one part of estate planning is vesting. Vesting is how you hold title, okay? And how you hold title is going to determine what happens to your house if one day you were to pass away. You follow me so far? So if you were to choose joint tenants, tenants in common, if you wrote single man versus so forth, those will all have an effect on what happens to the house after you pass away. And that's the purpose and the primary reason of these vesting methods. So let's start going through each of them with the simplest one first, with just one owner, one buyer, one owner on title, one person. When it's just one person, there's really only three choices. All right, there's only three vesting methods. We'll just pretend our buyer is named Bill, okay? Or let's call him David. Easier. Let's call him David. I don't know why David is easier, but let's call him David. So let's say David is buying a property. Well, David can technically, he's the only buyer, okay? He's the only person on title. Then he can hold title three ways, all right? These are the only three ways. He's gonna either be David, I'm so sorry. David, a single man. He could be David, an unmarried man, or David, a married man. All right, so those three ways: a single man, an unmarried man, and a married man. In any of those three situations, if David were to pass away and die, the property would go to probate. Probate is a court process where the state of California basically takes over and determines what happens and who can kind of take care of that particular property. Most people try to avoid probate because it's a very long, drawn out process, very complicated, and be very time consuming and costly. But in any of those three situations, whether David is on title as a single man, an unmarried man, or even a married man without his spouse, it would go to probate. So let's go into each one a little bit more. A single man, pretty self-explanatory. David is a single man. He's not married. He's a single man. An unmarried man. Well, what is an unmarried man? An unmarried man is just somebody that used to be married and is no longer married. So basically, it's no different than being single. All right, that's all it is. Now, here's the interesting one: a married man. All right, so David is married, but he wants to be on title by himself. All right, which is fine. He could be married and be on title by himself. But even if he is married and he's on title by himself, if he were to pass away, the property still goes to probate. Remember that. All right, it doesn't automatically go to his wife. Now, through the probate, maybe the probate court will say the property will go to the wife, but that is not for us to determine. All right, so that still goes to probate. Now, if David is a married man and he wants to purchase a property by himself, right? Generally speaking, the wife would need to sign a quitclaim deed during escrow, right? So again, let me repeat that. If David is a married man and he wants to buy a property and hold title by himself, generally speaking, his wife will need to sign a document called a quitclaim deed to release her interest during escrow to allow him to hold title by himself. And if you guys have done the transactions for your buyer this way, you probably know this to be true. Now, then the question becomes, is there ever a point where David, a married man, can be on title by himself without his wife signing a quitclaim deed during escrow? And the answer is yes, that is possible. But it's only possible when it's an all-cash transaction where there's no lender, all right, where David is buying the property all cash, or maybe David is using like a private lender. But most traditional lenders will require the wife to sign the quitclaim deed. So let's just say David is buying all cash. Then at that point, the title company will have no issue if David wants to take title without his wife signing the quitclaim deed. However, if David were to ever refinance to take out a loan later on, then the title company will say, hey, David, your wife needs to sign a quitclaim deed. Or if he were to sell the property, then at that point, the title company will say, hey, your wife needs to sign a quitclaim deed. I see that she never did one prior. Okay, I see she never actually signed one when you purchased it. So sooner or later, I guess, the quitclaim deed would need to be done. But buying cash does give a little bit of a flexibility. Okay. All right. So that's when there's one person on title. Now, when you have two or more people on title, then you have to choose. Then you have all these vesting methods that you guys, everybody has heard before, and which is tenants in common, joint tenants, community property, and community property of right of survivorship. Now, let me go through each one of these for you, and I'm going to make it super simple. All right. So when you have 2 or more people on title, then you have to choose one of these vesting methods. So let's say, Janie's on this call, and I know Janie, she's a good friend of mine. And let's say I'm the buyer, and I go to Janie and I say, Janie, I want to buy a house. With my friend here, and you know what? I want to have 60%, and my friend's going to have 40%. Well, for Janie, first of all, as a realtor, Janie knows I should never tell my clients which ones to choose. But what Janie is going to say is, well, if that's the case, then you really only have tenants in common to choose from, because tenants in common is the only option out of these 4 that allows people to hold separate interest. So if you want to have 60%, he wants to have 40%, or even 80, 20, 90, 10, whatever it may be, then your only option really is tenants in common, because that's the only option where you can hold separate interest. However, make sure you know tenants in common, although you have the flexibility to hold separate interest, does not have the automatic right of survivorship. What does that mean? That means if party A passes away, right, then that party A's portion has to go to probate. All right. And for some people, this would be like, yeah, no problem, but for others, they're like, oh, I don't really want it to go to probate if that was the case. But that's sort of the thing with tenants in common, right? You can have separate interest, but if one party were to pass away, that party's interest would have to go to probate. Now, let me pause right there and say, if you're taking a listing, right? If you're going to a listing presentation and your seller tells you, oh yeah, I'm on title with, another person, but that person passed away. Well, first thing you got to do is you got to call me and be like, Jerry, I'm taking a listing at 123 Main Street. The guy told me that the other person on title has passed away. Well, then we got to check, did they hold title as tenants in common? Because if they did, then you're in a probate situation, and your listing, unfortunately, is going to have to be kind of put on hold for a little bit until the probate gets situated. All right. Now, the second option is joint tenants right here, joint tenants. The joint tenants work almost exactly opposite of tenants in common, meaning everybody if they're same thing. If I'm going to Janie and I say, Janie, I want to buy a property with my friend here. Should I use joint tenants? Janie might say, yeah, you can use joint tenants. The thing with joint tenants is everybody on title has to hold equal share. All right. So if there's 2 of you, you both own the property equally. If there's 5 of you, all 5 of you own the property equally. But the good thing is if any of you were to pass away, there's no probate required. The property automatically goes to the surviving joint tenant. All that has to be done is you have to record a certified copy of a death certificate and do some other forms. Super simple. All right. So again, joint tenant avoids probate. So again, let's switch the tables. Let's say you're representing a seller. Seller says, hey, Janie, I want to sell this house, but the other person on title has passed away. Well, if we look and it says that their vesting method is a joint tenants, then you're good. Get that listing signed, put it on the market, and get it sold, right? All you're going to need to ask from your seller is, no problem, seller, get me a copy of the death certificate for the deceased. That's it. And it has to be a certified copy, meaning one of those color copies. And if the particular seller doesn't have it, then they have to order it from the county. All right. So make sure you tell them early, because sometimes it does take a little while to order those death certificates from the county. Orange County is the easiest because you can just go in person and they'll print a copy for you right there. But some other counties like LA County, it's a little more pain in the butt. So, but it needs to be a certified copy. But usually homeowners will have a few copies of it, so you should be okay. But it has to be a certified copy, not just a photocopy. But that's joint tenants. And anybody can be joint tenants, guys. Anybody can be joint tenants. So whether it's husband and wife, whether they're friends, siblings, cousins, acquaintances, anybody can hold title as joint tenants. Doesn't really matter. Now, for sake of simplicity, I'm going to skip community property and talk about community property right of survivorship because they're really so similar. All right, community property right of survivorship. And guys, if you want this flyer, let me know. You have my contact information in the chat box. Just send me an email afterwards and say, hey, can you send me that vesting flyer? And I'll email it over to you as well. Okay. So community property right of survivorship is very similar to joint tenants, very similar, except that it's only reserved to be used by married people. All right. Only to be used by spouses. And the percentage of ownership has to be equal, just like joint tenants. And there's also an automatic right of survivorship benefit. So meaning if the husband were to die, then the property would go to the wife. All we need is a copy of the certified death certificate. It's the exact same thing, okay? So then the question is, well, that sounds a lot like joint tenants, and husband and wife can also be joint tenants. Then what's the purpose of community property and community property of the right of survivorship, right? Sounds pretty similar. Well, I'll tell you what, the main thing about community property and community property of right of survivorship is the fact that it has a significant tax advantage if one party were to die and the other party were to sell, okay? And this is called the step-up tax base. Now, I'm not a CPA, and quite honestly, you know, I probably can't explain it as well as they do, but I'm going to give it to you in the most simplest form. Step-up tax base has to do with capital gains tax. What is capital gains tax? Capital gains tax is the tax we pay on money that we make, right? So let me give you some examples. I'm gonna mute some people here. Okay, awesome. All right, so step up tax base. And then with step up, we're talking about capital gains. All right. Now, let's use some super simple examples. I know married people have $500,000 exemption. Single have $250,000. This is called a 121 exemption. Let's forget about all of that for a sec. We're just going to keep it simple. If somebody in the year 1990 were to purchase a home for $100,000, okay, and today that same home is worth $1 million. This is the fair market value. Well, if this owner sells this home, they're going to make $900,000, right? So they have to pay taxes on the money they make because the base value is 100 and they sold for $1 million, they made 900,000. Okay, I know it's a little more complicated than that generally, but let's just keep the example simple. Well, this is how step-up tax base works. So let's say same scenario, right? Husband and wife buys the house in 1990 for $100,000, and they use community property or community property right of survivorship as their vesting method. Today in 2022, that same house is worth $1 million. Now, let's say the husband, he goes out for a drive, he accidentally gets into a car accident and he dies, right? He dies today. Well, what's going to happen is this old base value is going to get stepped up to the current market value on the day that he passed away. So let me repeat that. This old base value will get stepped up to the current fair market value on the day he passed away. So technically, this will then become our new base value, right? So let's say the wife is very sad, the husband dies, she says, you know what, I'm going to hire a realtor, I'm going to sell the house. So she calls Jasmine, hey, help me sell the house. And, you know, they put it on the market and they get it in escrow. And guess what? They sell it for $1 million because that's what it's worth. Well, since the base value is $1 million, they sell for $1 million, then there's no gains, right? She didn't technically make any money on paper. So therefore, she pays no capital gains tax. And hopefully that all made sense. That's the power of step-up tax base. And that's what you get with community property and community property right of survivorship. Now, you also get somewhat of a step-up tax base with joint tenants, but it's not as powerful as, you know, community property. You don't get like the 100% step up. So although we cannot tell our buyers which ones to choose, just between you and me, guys, most spouses, when they're taking title, they'll choose community property or right of survivorship now. And the reason being, they want that step up tax base. They also want the right of survivorship, meaning if one spouse were to pass away, it just goes to the other spouse. So that's a very, very popular and common way for spouses to hold title now. But again, you can't really tell them which one to choose, but you can explain to them the differences, and then let them make their own decision. All right. Now, let's continue. I said I was going to talk about trust, and that's what we're going to do because that's another way of holding title. So let's go back to this. So trust is another form of holding title. So meaning if you go and create a trust, if you go to an attorney, for example, you go to an estate planning attorney, you can say, hey, attorney, I want to create a trust. Okay, it's going to be called the Jerry Woo Family Trust. You can have that trust created. The attorney can create that trust for you. Now, one thing you can do is once you create that trust is you can change the title of your home to the trust, meaning it's no longer Jerry Woo, a single man, or Jerry Woo and Jesse, husband and wife as joint tenants. It's no longer like that. The title of your home is actually the name of the trust. It's Jerry Woo Family Trust, right? Jerry Woo, trustee of the Jerry Woo Family Trust. So you can actually change the name of the title of your home to the trust. Now, let me explain to you a little bit about how trusts work. So all trusts have three main roles, all right? And this applies to all trusts, no matter how complicated or how simple the trust is. You have your trustor, you have your trustee, and then your beneficiary, okay? Now, the trustor, that person is like whoever owns the trust. So say, for example, if me and my wife decide that we want to have a trust created because we have kids, right? We have two kids. I don't know if you can hear my 2-year-old screaming like he does every day in the background, but we have two kids. And one day, if something were to happen to us, we want to make sure that they're going to be okay, that, we know that they're going to get, our assets and somebody will be able to take care of them and so forth, right? So we're going to create this trust to make sure that everything that we have is sort of planned for. So we create this trust, we own this trust. So we are the trustors, we are the owners of this trust. Sometimes this is also called the grantors, all right? It's kind of the same thing, all right? Trustor, the grantor. Now, the second role is the trustee. This is kind of like the manager of this trust. So we've just created, as owner of this trust, we told the attorney everything that we want to happen. Well, we also need sort of like a manager, right? To make sure that these things are followed. So generally speaking, that person is going to be the trustee. And the trustee is going to be the one that signs all the paperwork for the trust. Now, usually, when the trustor is still alive, they'll make themselves the trustee. So for example, for my trust, my wife and I are the trustors, but we've also made ourselves the trustee. So meaning we sign all the paperwork related to this trust. But one day we're not going to be around anymore. So we also have to name successor trustees. In case we pass away or no longer able to sign, we have to have a successor trustee. And that's a person that we've named that we really trust, that will make sure that they'll follow all the rules and everything that we specified in our trust. And if you guys were to be taking a listing, then the person that you're going to be getting all the signatures from is the trustee. Okay, it's not the beneficiary, it's not the trustor, it's the trustee. That's who's going to be signing your contract, your paperwork, the grant deed. It's all the trustee. Lastly is the beneficiary. The beneficiary is who benefits from the trust, right? So like I said, I have children. Most of my assets and everything will probably end up going to my kids. So they're the beneficiary. They're the ones who's going to benefit from this trust. But for you guys, the agents, really, you don't care who the beneficiary is. It doesn't really matter to you. You really only care about who the trustee is. Who is the person that is charged with signing on behalf of this trust? That's really all that matters to you. The beneficiary does not matter to you. Now, what if the trustee has passed away, right? If the trustee has passed away, so let's say, remember I told you in my trust, I'm the trustee, well, my wife and I are the trustee of our own trust. Well, what if one day the trustees have passed away? If that were the case, then you as the listing agent needs to make sure you request a copy of the trust immediately from whoever is the person that called you. Because my guess is whoever the person that called you is probably the successor trustee. But how are you going to verify they're the successor trustee without seeing a copy of the trust? You follow me? So whoever calls you for that listing appointment, first and foremost, get that listing appointment signed. All right. Get the contract signed, get that done. And then the next thing you're going to do is you're going to request a copy of the trust from that person, and then you're going to forward it to me, all right, to us. And we're going to review it for you to verify who is the successor trustee, to make sure you're dealing with the right person, right? To make sure that you're not taking this all the way into escrow. You find a buyer, you get it into escrow, only to then find out the person that you're dealing with is not the successor trustee. And then now you can't sell the house because the actual successor trustee doesn't want to sell, right? So you have to make sure you get us a copy of that trust early. Another thing you have to get to us is a copy of the death certificate for the deceased trustee. Okay, so those are the two main things that you have to work on, is to get a copy of the trust and a copy of the death certificate. All right, and then we will then help you review to see who is the proper successor trustee, and then so you can sell the house for that particular person. Now, on the topic of trust, another couple of things. If the properties, again, a trust avoids probate, right? Because the trustee could pass away, but there are successor trustees, and a probate will be avoided. But we've also ran into situations where people create trust and then forget to change the title of their home into a trust. So I had a case a few years ago in Walnut, exactly the situation. The mom had a trust created, and she even had a grant deed done transferring the title to her trust. She just never recorded it. She never took it to the county to record. So then she ended up passing away. And her son reached out to the listing agent and said, hey, I'm the successor trustee of my mom's trust. I want to sell the house. And the listing agent signed the listing contract, quickly found a buyer, got it into escrow. And then when we pulled the prelim, we found out, hey, title's still under the mom's name. It's not under the trust, right? The son's like, the son has no idea what's going on. So he gave me a bunch of paperwork. And that's when I saw the actual deed changing the title to the trust that never got recorded. The problem is you can't record the deed now anymore because the mom's already passed away. You can't record something for a person that's deceased. So he ended up having to take it to probate, and the probate court issued a court order putting the title under trust. And then from that point, we could sell the house. But that took like 3-4 months, and it fell out of escrow like 2-3 times, I think. But eventually we got it closed. But that's a prime example of why you want to make sure title is put under the trust. And lastly, I'll talk about another way of holding title is you can have title under a company. So maybe you have an LLC or a corporation. You can have the title, change the title of your home to the name of the company. So for example, I have a rental property and I put the title of that rental property under my LLC. So you can do that as well. Now, if you were to take a listing and title is under a particular entity like an LLC, then you need to actually make sure you get their entity documents, like their operating agreement for their LLC or their bylaws for their corporations, because you need to make sure whoever you're talking to can actually sign on behalf of that company, right? So say, for example, your seller has a title under an LLC. It's called, Apple LLC, right? Well, how do you know that the person that you signed the listing contract with is an authorized signer for Apple LLC? So of course, we have to make sure we get the operating agreement for that. And we have to let's get it early as possible. And I always like to get things as early as possible to make sure there's no delays. So one of the things that I actually do for all my agents when we work on a file is I personally review every single preliminary title report. And then I'll send an email to that listing agent saying, hey, your prelim is done. Here are the bullet points. Here's red flags. This is what you will need. This is, and so forth. So, and I send that out immediately when the prelim gets done. I've done this every year for the past decade plus. I've reviewed thousands of prelims. So it takes me, just a few minutes to kind of look over to tell you, hey, this is what you're going to need. But anyhow, so that's what it is if it's under a company. And And I think I'm going to stop right there. We have about 10 minutes left. I want to save the last 5-10 minutes or so for any questions in case you guys have any. All right, Joy asked, if one of the joint tenants passed away with the living trust, can he still give his share? So no, if let's say title is held under A and B as joint tenants, all right? A is an individual, B is an individual. Let's give them names. Let's say it's held under David and Mary as joint tenants. If David passes away, the property is going to Mary. That's it, okay? Even because he didn't have it under his trust. Now, he may have a trust, okay? But again, the title is under him as an individual and Mary. So it goes to Mary if he were to pass away. The one way he could do it, Joy, is if title was David's trust and Mary. Okay, so he would have to have his portion under his trust, and then Mary's portion is under her individual name. But when one owner is under a trust, the only vesting method is to choose from his tenants in common. Okay, but David doesn't have to worry about probate because David's portion is under a trust. If he were to pass away, then his successor trustee would take care of it. But if Mary were to pass away, since her portion is not under a trust, it would end up going to probate. Because remember, when one owner is a trust, the only vesting method is tenants in common. And tenants in common does not have a right of survivorship benefits between the two parties. Hopefully that answers your question, Joy. Good question. Anything else, guys? Don't be shy. Anything is a good question. No, nothing? Well, okay. Well, guys, make sure you look at the chat box. My information is right there. I would, if you enjoyed this session, if you found it informative, thank you so much. I would love an opportunity to work with you guys on your next escrow. So if you have an opportunity to choose which title company to work with, please consider myself. My information, again, is in the chat box. I would love an opportunity to work with you. Thank you so much for your time. If you want a recording of this session, make sure you check out the Tri-County website 1 or 2 days. I think Laura said it's going to take about 2 days. And then the recording will be on there. All right. Thank you guys again. Enjoy the rest of your day. Happy holidays and take care.